Hey, good afternoon, everybody. Welcome to our webinar today. I'm Mike Fielding. I'm a partner in the food system at Husch Blackwell, where I help lenders deal with distressed debt issues. And today we're going to be talking about our quarterly review of commercial and ag lending disputes. I know we have a few people just joining in at the top of the hour, so while they're joining in, I have a few housekeeping items to read here, and then we'll dive into the program. So at the bottom of your console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, you can submit them in the question box. I will try to answer all questions today, but if we run out of time or if the question is just too involved or too complicated, I'll probably need to follow up with you individually via email. There is a PDF presentation available in the program folder, and there's actually two. There is a copy of the PowerPoint presentation, and then I prepared a separate Word document which has the contents of the cases that we're going to be discussing, but then there are some additional materials or cases at the end of that document that were kind of noteworthy items that candidly we're not going to be able to get to, but you can download the document and get the parenthetical explanation on those interesting cases. For those of you that are attorneys, my condolences, but for those that are, this program has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow with a recording of the webcast for watching and sharing. And then at the end of the program, there will be a short survey. We'd really appreciate if you could give feedback in that regard. And so let me just really quick give an overview of what I'm doing here. As the name of this presentation says, it's a quarterly review. And candidly, what I've been trying to do is figure out a way to really bring value to the clients that we serve, which are predominantly lenders dealing with lending, commercial and ag lending disputes. And so I had this idea several months ago, which was on a quarterly basis, I'm just going to get the interesting cases that have come out that have really grabbed my attention and put it together here in a format that will be educational. Quite candidly, I'm genuinely trying to help you, because I think a lot of times we learn best learning from the actions of others. We're trying not to repeat the mistakes of others, but then sometimes also learning what others did right as well. And so this is a way to do it. I'll be doing this quarterly. We're going to be doing one in June, one at the end of September, and then the last one will be early December. Today I'm flying solo. And so you'll see that I've done this in a kind of a question and answer format with some key takeaways. The one thing I'll say up front is that if you don't like the format, or if you think I need to improve on it in any way, please let me know, because I genuinely am here to try to help and educate you. Okay, so let's get started with that. The first case, this actually comes out of Illinois, and we have the question here. I call it a quiz, and the good news is we're not going to see the results, because I'm not into shaming or making anybody feel bad, but what I want to do is ask the question. We're going to pause, and I want you to think to yourself, what do you think is the right answer? Because it's important it's always nice to get that check. Am I right or am I wrong? And then obviously if I'm wrong, why? Or sometimes I may be right, but for the wrong reason. And we want to be right for the right reason. So this was a really interesting case that came out of Illinois. In this case, the lender loaned the borrower about $1 million. The lender properly perfected its security interest in inventory. Now, what was unique about this situation is the borrower, when it's doing the initial loan document, says or represents that it is legally authorized to buy or acquire fireworks. And then it turns out that the borrower actually didn't have the proper authorization to get the fireworks. Well, everything goes kaboom, no pun intended. All right, bad joke there. The loan obviously explodes, goes bad. And after, of course, the borrower has acquired the fireworks, and then there is a challenge to the lender's lien. And the argument is that, hey, the borrower didn't legally properly have legal title or didn't legally acquire these fireworks. Therefore, the argument was that the lender's lien should not attach. And the question for you is, Did the lender's lien attach? Did it properly attach? So pause. What's your answer? Think about it. Let's see how the court ruled. The court says the lender's loan was proper and attachment properly occurred. And the key thing here is that the lender, when it was doing this transaction, it didn't have any idea that the borrower/buyer is procuring the fireworks illegally. And the transaction itself did not contemplate illegal activity. Therefore, the lender's lien in the fireworks, the collateral, remains intact. So you can see the key takeaways there that I have at the bottom. Obviously, if you're going to do a loan transaction, and let's say you were doing like heroin or drugs, heroin's actually a bad example because in some situations, if it's being properly legally done, it's a controlled substance, but there can be an attachment. But if you have like cocaine, which is clearly illegal, you're not going to be able to attach to, say, something like that. But if it is a regulated substance, you can still get attachment in it. The problem that you will run into is when you get into the liquidation of the collateral, you're going to have some special problems that you're going to be dealing with. And I think substances are the prime example of this. Alcohol, for example, maybe you have inventory on some liquor store. How you dispose of that alcohol, it's obviously a regulated substance, medicines, et cetera. But it goes obviously beyond medicines. There are other regulated items out there in the world. I think one that is a creeping problem that we will see lenders dealing with more in the future are in states that have legalized cannabis. And so you get this disconnect where under state law, the substance is legal, but under federal law, it is illegal. Well, when you are looking at a lien, well, where does that arise? That arises under state law, but what then happens when you go to dispose of it? You can see that it's going to create some issues and headaches down the road. It's like there's always something to put gray hairs on our head, right? So that's one that I think is out there and will be coming, especially as you have maybe in the agricultural sector, you have some borrowers who maybe don't tell you that they want to experiment growing hemp or cannabis, and then they do, and then suddenly you find, oh, my borrower planted a field of hemp. I do have a lien in crops, right? So my lien should attach, but oh, it's a controlled substance. So anyway, that's that. Let's go on to the next one. Here's the next question. This is an interesting one. This case comes out of Virginia, and it's dealing with a lender who had a blanket lien in the contractor's assets. And there was a line of credit agreement that required all of the AR to be deposited into an account at which the lender in turn would sweep. Now, like any big borrower that's a construction company, they will almost always have a surety company that's out there. And in this case, the borrower had a general indemnity agreement with its surety. And I don't know if it's in every single surety agreement, but I'd say probably in the vast majority, if not all, surety agreements tend to always have two things. They'll grant the surety a lien in the borrower's assets. That's language that's very common in there. And then there is also frequently language in the surety agreement that says if there's like a default of some sort, then monies that are coming in are going to be held in quote unquote trust. Okay. Now in this case, well, you can see here in the question that that's the situation that occurred here, that you have that trust language here. There was no separate trust account created. That's an important fact. And the borrower defaults, the lender swept $2.5 million out of the account. The surety sues the lender for conversion. You converted our collateral, and also arguing unjust enrichment. And the question is, who wins, the lender or the surety? All right. So think to yourself the answer here. And the answer is, in this case, the lender wins for a few reasons. And these are important reasons. First off, the surety never filed a UCC1. So and maybe I should have put that in the question. It almost feels like a trick question where I didn't disclose that. Got to keep you on your toes, right? Anyway, the surety never filed the UCC1, so it was not properly perfected in like accounts and things like that. But then when the money's come into the account, just filing the UCC1, that's not going to cut it. You have to have an account control agreement if it's, with another lending institution, and no account control agreement was ever created. And the Virginia Supreme Court, in looking at this, said, hey, when those monies come in, that creates a debtor-creditor relationship. And also, the lender had never agreed to this trust language. So even though you have the surety and the borrower saying these monies are going to be held in trust, the problem is the monies from those jobs are going into an account at the lender, which is in a debtor-creditor relationship. And the lender has never agreed that these monies are going to be held in trust. And that was a really key point that the Virginia Supreme Court then ends up ruling in favor of the lender, because A, you don't have perfection, and B, you don't have any agreement that the funds are going to be held in trust. And so the takeaways here are, I think, are my bullet points down there at the bottom of the page. If you have a borrower and they default, and if there's a surety, there's a pretty good bet that you are going to be in a fight with the surety as you get some of these monies trickling in. It's really critical that you make sure that you are perfected at each step of the process. I cannot emphasize that enough. A lot of times we have this gut reaction of, oh, I have my security agreement, and yes, I filed my UCC1. Oh, I'm okay. That covers a lot of different items, but the problem is you can get collateral that gets then turned into cash. And the problem is you want to follow that cash all along the way, all along the process. You want to be perfected at each step of the process. And so that cash, that AR, is going to be coming into, it should be an account at your institution where, again, you are perfected with the right of set-off, so that you can be in a first priority position. And then obviously if they're using it as an operating account, they'll do their withdrawals, but you're perfecting at each step of the way. If you run into a situation, right, and this happens a lot, the loan relationship is deteriorated. And so the borrower then moves its accounts to some other lending institution. Now you're in a problem because maybe you have a lien in AR. That AR is getting turned into cash, but if that cash is then going into some other bank and you don't have a deposit account control agreement there, then after the 20 days, you're potentially at risk of losing your lien in the cash, and that's a real problem. And so you need to, when you have a borrower moving the account to some other institution because the relationship has become acrimonious, you need to take a good, long, hard look at your own loan documents and say, does that constitute an event of default? What do we need to do as a lender to protect ourselves? Again, it's obviously very situational specific, and there's a lot more facts that go into this. But I'm just trying to plant the seeds out there so you can be thinking about this and try to be aware of maybe the pitfalls that are out there. The final bullet point there that I have there is that, if you get into some sort of an agreement with the surety where, okay, money's coming in going forward are going to be in a trust account, you better make sure that you have enough collateral to satisfy your debt somewhere else. All right, let's move on. This next case comes out of Texas. It involves the Bank of Shallow Water. And so when you hear the word shallow water, it just sounds like a bank in Texas, right? This is an ag case. We can have some implications beyond the ag world, but in the facts are pretty simple here. You have lender number one. They have a blanket lien in all of the farmers' assets. This was a cotton farmer in this case. Lender number two comes in and provides a purchase money security interest financing to the borrower so the borrower can buy the seeds and the chemicals to grow the cotton crop. And the lender number two timely filed a UCC1, a PMSI lien. Obviously, the crop is harvested, the proceeds come in, but then there's a fight between lender number one and lender number two as to who's in a first priority position. So, big drum roll, what do you think? Who wins here? Lender number one or lender number two? Let's see what the Texas Court of Appeals said. The Texas Court of Appeals said here that, I say no, the question was, does lender number two have a priming lien? And the answer is no. And what's really important here is when the Court of Appeals was looking at this, they said, listen, seeds and chemicals are just two inputs for crops. They said beyond that, you have, the fertilizer, soil, water, which, water is increasingly a commodity there, and then the farmer's labor. And then you mix it all together and you have to wait time, and then voila, you get a crop. And the point here is, I have the quote here from the case. It says the crop was not the result of the sale, lease, license, exchange, or disposition of the seed. The seed was planted, cultivated, not transferred or disposed of, and the crop was the resulting product. Okay. So what are the takeaways here in this situation? Well, one important point, and this applies to not only people in the ag sector when you're dealing with loans and crops, but also if you have another process where you're getting some key input and then getting an outcome of some sort. The question is, when do you get the PMSI? And I think the takeaway here is, if you are maybe providing PMSI financing for this one key ingredient that's going into the mix to get something out on the other end, under the rationale of this case, the fact that what you're providing the financing for, this key ingredient, that may not be sufficient because there's these other components that are factored into the mix to get the final product. And so if you are a lender and you think you have a PMSI in the crops because you provided financing to buy the seeds, what you really need to do is get a subordination agreement from any other lender that's out there. That would be the best protection for you. The idea then is that you can protect yourself, provide the financing, and if you have the subordination agreement, then you're, by contract, you're put into a first place position. But if you're just relying on the PMSI, you're going to be in trouble. I think maybe a good way to think about the PMSI liens is you're getting a PMSI in, an object, something tangible. I guess it could be intangible if it was like intellectual property. But the point is, it's the same thing. You're providing the financing to get this thing. This thing then is owned by the debtor. This thing then gets liquidated, and we get the proceeds from it. So it's like I'm holding a Chipotle burrito, right? And I'm just walking it through the process. And that's a bad example. We'll talk about a car. You have a car. You're going through the process, and it's still at the very end, it's now being liquidated and turned into cash. I think that's a easy to remember way to conceptualize the PMSI. It's this tangible item that's working through the system. And if you properly perfect, then you'll get into your number one position there. All right, quiz number 4. This case was an interesting one, comes out of a bankruptcy court down in Texas. And here you have a lender who pre-petition had a properly perfected lien in accounts. The borrower filed for bankruptcy, and the borrower had some unencumbered real estate. And so post-petition, the borrower enters into a real estate contract to sell the property, and the court approves the sale. But then the lender comes in and says, hey, I have a lien in accounts. You've taken this unencumbered property. Once you entered into this contract, the sale agreement, right, there was an account receivable. The borrower was slated to get some money. And therefore, I should get the money. I, the lender, should get the money and pay me off. And the question is, can the sales proceeds be applied to the lender's lien? So we have three options here. Number one is, yes, you can, because the real estate constituted a right to payment under the UCC, and the lender had a properly perfected lien in accounts. Option B is no, even though the right to payment under the real estate contract is an account, the right to payment arose post-petition, and it's not proceeds of the lender's pre-petition lien. Or C, a lien on accounts under the UCC extends only to accounts based on the sale of goods or services and does not extend to proceeds of real estate. Okay, tough questions here. So think to yourself, A, B, or C. What's the answer? Well, let's see. The answer, whoops, clicked the wrong button, apologize. The answer here is B. And the reason for this is that under the bankruptcy code, you have section 11 USC 552, and it creates a very bright line between pre-petition assets and post-petition assets. And what the law says is that the lender has a lien in the pre-petition assets, but assets that are acquired post-petition are not subject to the lender's lien unless it's proceeds of the lender's lien or unless the lender has been given an adequate protection lien in those proceeds. Okay, so what are the practical takeaways here? The one thing I really liked about this case is you had a really creative lender, and you know, if we're heading into this recession like a lot of people think we are, you know, people have been saying that since 2020, right? And we'll see if it ever comes. But if we do head into the recession, more of an aggressive nature by the lenders will be needed to protect their interest. And the question is, what is collateral? Well, if a borrower is selling unencumbered assets, right, that may be an account. We have a lien in the accounts receivable. We can make a pretty good faith argument that that is now subject to our lien. So outside of the bankruptcy context, the lender probably has a really good argument here that it is entitled to get the proceeds from the sale of this real estate. The problem is this case arose in bankruptcy, and you had the operation of Section 552, which cut it off. So A, be aggressive. We want to do that. The other big point here is that if your borrower is filing for bankruptcy, you want to jump in and make sure that you are adequately protected. And that adequate protection can come in the form of replacement liens. That's very common. It may come in the form of continued payments by the borrower to protect against diminution of value of collateral. All right, let's keep moving on. This is an interesting case. This case comes out of Missouri. Gets in the consumer context, but the concept will be applicable in the commercial context as well. So you have a Missouri resident who buys a Kia Sportage car from that has a New York title from a Kansas dealer. Sounds like the beginning of a bad joke, right? But these are the facts, okay? And so the PMSI lender, and it was a bona fide PMSI loan, I'll say parenthetically, they filed the notice of security interest with the Missouri Department of Revenue. The vehicle was never retitled in Missouri. The borrower moved to Kansas and files for bankruptcy. And the question is, does the lender have a valid lien? Let's pause, think about the answer. And the answer is no, okay? The reason for that is the trustee steps in as the hypothetical judicial lien creditor. And the problem here is that even though the car is being bought in the Midwest, it is titled under New York law. So the certificate of title is there in the state of New York. And that is where the lien should have been originally recorded. Because I don't know if it's every state in the country, but most states, if not all, certainly I know like Kansas and Missouri, for example, and there's several other states that are this way, they've essentially gone to the e-title registry. And so if you want to get your lien noted on a car, a truck, a trailer, you know, with a VIN number, you have to file a notice of security interest with the Department of Revenue. And there are a couple ways that you do this. If you're providing the PMSI financing versus if it's, you know, where it's being bought from somebody else, or if it's maybe they're refinancing and you're taking out the old lender and you are putting a lien as part of the refinancing. We won't get into the mechanics of that. But the point here, the super important point, is don't delay in filing that notice. Your UCC1 is not going to cut it. You have to file it with the Department of Revenue. And most states allow you to give the title information to the borrower, and then the borrower can record it and get it retitled. But the problem is sometimes borrowers delay, and especially if you're dealing with a PMSI loan and you have your 20-day window and you give it to your borrower and your borrower just sets it in the desk drawer and then picks it up 8 weeks later, well, you may suddenly find that you've lost your PMSI lien. That's even assuming that they title it in the right state, okay? So I think I've probably beat this one to death, but the key point here is what state is the title in? Let's record our lien there. If the borrower then retitles it in, like, say, Kansas, then you want to just double check that the lien is showing up. And if not, make sure you file your notice of security interest. All right. This one comes out of Vermont, number 6. And pay close attention to this one. So you have a security agreement, and it gives a lien in all of the borrower's property in the possession of or subject to the control of the lender, whether existing now or later, and whether tangible or intangible property, including, and it goes on to say, the borrower's account at Merrill Lynch. Now, the court rules that the lender's lien doesn't attach. And the question is, why? What do you think? Why does the lender's lien not attach here? Well, the answer is this is a self-inflicted wound, all right? Under the security agreement, and let's go back here at the language to look at the question. You'll see here it says it's all of the borrower's property in the possession of or subject to the control of the lender. Well, the problem is this account is at Merrill Lynch, so it's clearly not in the possession of the lender. And the lender also did not have a deposit account control agreement with Merrill Lynch. So the problem is this precondition of in the possession or subject to the control of the lender wasn't satisfied, and therefore the lien did not attach. So this is just a pure self-inflicted wound that happened here based on the wording of the security agreement. It was, and I don't know who drafted this. I'm just getting this case that's coming out, and I'm like, oh, that's kind of interesting. And so this precondition was never satisfied. So what's the takeaway here? Well, the takeaway is the language in your security agreement actually matters. And I know the vast majority of you listening to this are at banks that probably use Laser Pro documents. And I'll candidly say probably the vast majority of all security agreements I've looked at in the past typically don't give me queasiness in my stomach when I'm looking at the language. What I am saying, though, is that there are some situations when you have to look carefully at the language and say, do we have this little caveat, this language that might trip us up or create problems? If you see that, and if there's this question of attachment, do you want to run out and publish that to the world? No, that's a mistake. You want to quietly get it resolved. And how do you resolve something like that? Well, you resolve it by getting new loan documents in place that give proper attachment. And so you need to work through that. The practical problem I think that we run into is most of the time these problems are not identified until the loan gets into trouble. And that's when you have somebody that didn't originally underwrite the loan. They're actually looking at it with fresh eyes and they say, oh, we've got this problem here or this problem there. That's when it comes up, and that's when you have to typically try to work through it. So, all right, this next case comes out of Iowa, and the case here is the lender had a blanket lien on farm assets, which included livestock. The borrower defaults, the lender accelerates the loan. All right, very common scenario. And this happens clear back in October of 2017. So the borrower has to keep the cattle alive, the dairy cows. So the borrower starts buying feed from a vendor who obtains an agricultural supplier lien for the feed for the 2017-2018 winter. Ultimately, despite all the efforts to work with the borrower, things just don't work out. So the dairy closes, the cattle are sold. There are $1 million in proceeds. The lender and the vendor fight over the proceeds. Question is, who wins? Let's think about it. And you may be saying, hey, that's unfair. You haven't given enough facts. Maybe so. One big key I've given you is Iowa. So maybe that helps there. The answer here is the vendor partially wins $108,000, but then the court had to remand for further factual determination. Now, my big key points here are these, and this is particularly poignant in the ag space, but certainly even outside of the ag space, there are other liens that can attach. The point here is that every state has ag liens, adjuster liens, things of that nature that will protect vendors and suppliers. There is no one-size-fits-all format for these liens. They really vary quite a bit state to state, even neighboring states like Missouri and Iowa are neighbors, but the ag lien laws are very different. And Iowa has very robust lien laws for suppliers, okay? When you get into a situation here and you're the lender, you're really faced with some big dilemmas because you have the livestock, they have to be kept alive. Somebody has to supply the feed. The question is, who's paying for the feed, right? And everybody wants to be a free rider. Somebody wants, the bank wants the vendor to sell the feed on the hopes that, with the lender hoping he gets paid down the road. And the bank wants to keep the livestock alive and then liquidate it and get paid in full. Well, the lien laws are there to protect the vendor in that situation. My point here is that when you are dealing with these situations, you need to know who's supplying the agricultural inputs, where are they being used on the farm, and are there going to be disputes? And I think the one point that maybe comes out of this case is that sometimes it's a real headache. And I get it that, you've poured money as a lender into this borrower. You feel like they're a black hole. I guess on the farm, it's just a muddy pit, right? Everything's getting stuck and nothing's coming out of it. But the concern is if you pour money in as a protective advance, then there's no question that you as the lender are in a first priority position on the cattle. If you're not putting the money in, then you get into a situation like, which is here in Iowa, which is, what bags of feed or feed that was provided, what did it do? Which cattle were actually fed, which ones weren't? And that gets incredibly fact intensive, and it's really hard to figure out who goes where. And that's actually why the court remanded in this case, because it was clear that 108,000, that the supplier was clearly in first position on the 108. But on the remaining, roughly 800 plus thousand, there were factual determinations. And that just gets messy, right? Because then what are you doing? You have this pot of money, you have attorneys on both sides fighting over it, which means everybody's expenses are going up. And then that just makes the overall recovery take longer to get. And then there's less of a recovery. Even if you win, you've consumed some money paying attorneys. And that, frankly, from a profitability standpoint, it's not ideal. You want to be able to hopefully get the funds and pay down the debt. All right, let's move on to the next one. So this next one is our quiz number 8. And in this situation, you had a security agreement that granted a lender a lien in the borrower's accounts receivable. And what was unique about this case is the agreement also allowed the lender to direct account debtors to pay the lender directly, even if there wasn't a default under the loan agreement, okay? But the kicker here is that the security agreement didn't assign the accounts receivable to the lender. All right, so what happened is the lender ended up sending a notice to these account debtors. Account debtors, that's kind of fancy language for a third party that owes the borrower money. So you have the lender sends an account notice to these third parties saying, hey, I've got a security agreement. You need to pay me directly. And the question is, who should the account debtor pay? Should the account debtor, this third party, should they pay the borrower or should they pay the monies to the lender? What say ye? All right, think about the answer. Let's see what the New York court said. So this case comes out of New York, and the court said that the account debtor, this third party, has to pay the funds to the lender. And then the court goes under the UCC section 9406, says, listen, an assignee includes somebody that holds a security interest in the AR. So even though the term assignment wasn't used, it said functionally it still treated it as an assignment. I think the important takeaways here are, A, we want to go back and look at the language of our security agreement. What was unique about and you can see who's the lender here, Worthy Lending LLC, right? This is not a Main Street bank, a traditional lender. This is going to be a private lender that's out there. But they had put into their agreement this ability to collect the AR even though there wasn't a default. Okay, that's completely legal. If the borrower and everybody agrees to it, that's fine. You can do that. So you want to look in your loan documents and say, do I have the right to exercise this remedy, even though there's not been a default? Clearly, there was this contractual right to do so. And then in this situation, the borrower had given up that right. So when the lender is sending out these notices to the third parties, it was properly entitled to collect the monies. There's another case we're going to discuss at this coming court. It's actually over here in my pile of cases that I'm already starting to build up, where we're going to deal with not this case, but a continuation of this issue. So stay tuned on that one. So question 9A and 9B, they actually come from the same case. So in this situation, you had a lender repossesses a vehicle. They send a notice to the borrower, and this is a consumer, that it's going to be sold at a private sale. The vehicle is then sold at a dealers only auction. And then the borrower challenges the sale, claiming that the notice was improper because it didn't properly describe how the vehicle would be sold. And so the question is, when you sell a vehicle at a dealers only auction, is that a public or private sale for purposes of the UCC? What do you think? I mean, if you're familiar with, I know there's Manheim, I forget, there's like 2 or 3 other big dealers out there. And my brother-in-law, he's in a different state, but he goes up to the car auction every week. He has one of the license, and we go up to these auctions, and there's quite a few people that are there kind of mulling around that are making bids on vehicles. Is that a private or public sale? Well, the court in this case said it is a private sale. And the reason it was deemed to be private is because only dealers could participate in the auction. And you had to have kind of this special license or special permission to be there on site to make a bid on the equipment. Therefore, it's deemed private sale. Now, I have a blank on the key takeaways because that's where we get into question 9B. All right, so same case. In this situation, the lender mailed a UCC notice to the borrower, and this is a pre-UCC sale notice. And then, let me back up. This is the Missouri Supreme Court. They get talking about the pre-UCC sale notice. The notice is returned in the mail. So you send it out to last known address, but then guess what? It comes back. And as the person's no longer living at the address. And so the question is, does the lender need to make a second try before proceeding to the sale, or can the lender simply go forward with the sale even though the notice was returned? And what the Missouri Supreme Court said is that the lender needs to take another stab at notifying the borrower, all right? I realize people are going to hear that and kind of go, ugh, because consumer borrowers can be fickle-ish in the sense that they were there one day and then they've moved on. And it may be a situation where, they may be living with a friend, a relative, maybe they're there for a few months, they then go to somewhere else, they then move on, right? I'm saying this, and every one of you that have teenage kids or older teenage kids say, well, that's describing my son or my daughter, right? I have 6 kids, and I'm describing my son right there. He was living at home. He went and lived with my in-laws for a few months. He's now back at home for a few weeks. Now he's going to go out of state in a few weeks from now to work a summer job. Where's he at? How's he going to get noticed? So fortunately, he doesn't have a loan. We don't have to worry about that. But you get my point, which is if you want to have this sale be deemed proper, you need to make an effort to get notice to the borrower. And I realize sometimes that's a bit of a pain to do. The problem is if you don't give notice, then it can later be challenged. And especially when you're in the consumer arena, that can get really expensive because you're not talking about a whole lot of money there. All right, let's move on to the next question. So you have an unsecured lender who gets a judgment against a borrower. The lender then serves a garnishment on a bank. The court orders entered regarding the disbursement of the funds. The check is cut and the funds are given to the lender. And then the borrower later files for bankruptcy. So then the trustee sues the lender on one of these 90-day preference clawback actions. And the question is, when did the garnishment occur? And you may like rolling your eyes, go, why does this matter? And the answer is it matters because when the transfer occurs is going to determine when that 90-day clock starts to run. And that's that window of time that the trustee has to avoid the transaction. So when do you think when did the transfer occur? Well, according to the Seventh Circuit Court of Appeals, which covers Illinois, Indiana, and there's one other state in my mind's drawing a blank, but they're in the Midwest, Wisconsin. The transfer occurs when the monies transfer hands. And the Seventh Circuit here relied on a Supreme Court case for this. Now, you're saying, well, I'm a lender, I'm just loaning monies, why does this matter? Well, it matters because if you are out there getting judgments and collecting, what this case is saying is that 90-day clock is not going to start when you serve your garnishment on the bank, right? That 90-day clock is actually going to start when the court cuts the check to send the funds to you as a lender. And that can actually be several months, depending on how contested the garnishment proceeding is. And so when you're trying to say, are we insulated in being able to keep these monies, the bad news for lenders is that 90-day clock really doesn't start to run until the time that you actually get the check being cut with the funds being paid to you. So that's a downside. A practical takeaway, you can see it down here in the notes, is that a lot of times we need to differentiate between personal property and we need to differentiate between real property. And the reason that's significant is if you get a judgment and then you record that judgment, that is going to become a lien on real estate that the judgment debtor owns. And there are, the argument is that the lien is the transfer. And so that's when you want to wait because your lien has become perfected, i.e. the judgment lien attached to the real estate. And so one common rule of thumb is don't foreclose on that property for 90 days, because if you get the judgment lien and then immediately foreclose on it, then they could avoid it. Now, the problem is maybe you get the judgment lien and you're waiting for the 90 days to go by and then they file on day 80. They can then go back and avoid the imposition of the judgment lien as a preference. And I know this is getting really technical and it's late in the afternoon or late at the lunch hour and you're like, oh my goodness, how can I handle this? Just trust me on this one, all right? The point here is that they could try to avoid the lien, but if you get past that 90 days, then there's a good argument that they can't avoid the lien, therefore you can foreclose and get the proceeds. The issue with the garnishment is that this court is saying that, hey, listen, the transfer doesn't occur until the cash is actually sent. So interesting point to think about. Here's another one. Let's go back into the UCC arena. This is a two-part quiz here. So under this one, you had a secured lender. They send a UCC notice, and they had repossessed the equipment. And the notice says, "Hey, the equipment's going to be sold in an online auction on October 2nd." Well, something happens along the way, and that online auction actually doesn't start until October 12th, and then it goes for almost 2 weeks. It concludes on the 26th, and actually, that is 2 weeks exactly. But the question is, there's a discrepancy. And does that invalidate the sale? Good question, right? Well, this case comes out of Pennsylvania. And what the court said is that, no, it doesn't invalidate the sale. And here's the key reason, because the notice said the auction's going to start on October 2nd. And yes, there was a little bit of mess up. The auction didn't start till, October 12th. But guess what? The auction did occur, and it was actually open for 2 weeks, and then it closed. And the court was really focused on this 10-day notice and the question of whether the debtor had the opportunity to exercise redemptive rights or, essentially come in and cure the default to keep the collateral. And the court was like, it's not that big a deal because proper notice was given. And even though you have this bit of a delay or this, caveat where you get this stutter, so to speak, on the actual sale date, you still had that initial 10-day protective period. So that's good news for lenders in that situation. Now, the key takeaway, we got to actually go to the next slide, which is part 2 of the question, and that is, does an online auction constitute a public sale? I mean, I had my thoughts on this one, and what I was surprised about was that this was actually apparently appeared to be an issue of first impression with the court. This is a no-brainer. The answer is yes, it is a public sale if it's an online auction. So good to know. I mean, it's one of those, it's kind of like, duh. But, we had the question with the dealership, and it was a private sale. And I think the question here, if you're saying, well, how do I tell if it's private versus public? The question is going to be who can show up and play, who can show up and bid. And clearly, if it's an online auction, you're going to have to register. But if it's generally open to the public to register, it's going to be deemed a public sale. Okay. Let's do another question. And I know we're about out of time here. And I know we've had a couple questions that come in. So I'm gonna do this quiz number 12, and then we're going to answer a few of these questions that have popped in. Okay. The question is, following the bankruptcy filing, the lender effectuates a set-off without court approval. And then the lender gets pressed to undo the set-off. The lender says, I think I'm fine. I think what I did was okay, and I'm not going to do nothing. And guess what? Even if I'm wrong, the worst that can happen is I'll just be forced to cough the monies back to the estate. So the lender's sued for an automatic stay violation. You're the judge. How are you going to rule? All right. Well, in this case, it didn't go well for the lender. All right. The lender's held in contempt of the automatic stay, and it had to pay attorney's fees and costs. And the court found that the lender willfully violated the automatic stay by effectuating the set-off post-petition and then maintaining that set-off when it was challenged. And the other point here is that the lender's subjective belief that it was okay was not a proper defense. All right. So there are some really important takeaways here from this case. The first big takeaway is if you're a lender and if you're arrogant, don't expect that to play well with the bankruptcy judge. All right. It's, I think insurance companies tend to be really despised. For some reason, people don't like banks, even though it was the bank who gave the money in the first place, right? They always forget the generosity in loaning the money in the first place. They always just want to focus on the bank, right? And I admitted I'm a little bit jaded with that comment, but you get where it is. Banks are not the most sympathetic clients when you're getting in front of judges and juries. So you always want to keep that one in mind. The point here is, or another point I should say, is if you are familiar, there was a case that came out a few years ago out of Chicago. It went up to the Supreme Court and the city of Fulton. And the issue is if the lender has taken property and then essentially just does a do nothing, the question is the lender violating the automatic stay if the lender does nothing? And the Supreme Court, in a really good decision for lenders, ruled in favor of lenders, saying if you're just kind of hands off, we're not going to just voluntarily return that property to the estate. That is not a violation of the stay because you are not acting. And that was kind of the key term in that case, is whether or not the lender was acting. What happened here in this particular case, is our Capita decision coming out of New York, is that the lender had, after the bankruptcy filing, had effectuated a set-off without getting relief from the automatic stay. And that is a big no-no. If you want to effectuate a set-off, you have to get relief from the automatic stay. Now, So a practical question is, well, what happens if I think I have the right of set off, my borrower files for bankruptcy, and I don't want the borrower to get the money that's in the deposit account? I want to set that off and have it go to me. Well, the practical answer is you want to immediately freeze the account, put an administrative freeze, so we're not doing anything. But then you really need to pretty promptly get into the bankruptcy court and ask for relief from the automatic stay, or alternatively for adequate protection. Because, you know, a real common scenario is the borrowers filed for bankruptcy. They have that cash. They thought they were going to be able to use that cash to operate. You're saying, well, that's my cash that should be used, or excuse me, that's my collateral that should be used to pay down my debt. And I don't want that to go out the window unless I know that my debt is going to be paid in the future. So that's where you get into the big tussle. Is the lender adequately protected? Can you do the setup? All right. So that's why you want to put the administrative freeze, protect it, you know, just freeze it in place, but don't set it off immediately. You want to go in court and get permission to do that. All right. A question here, and this goes actually to the earlier, I think it was the third decision that we talked about, but I want to weigh in on this one. The question was, did the debtor acquire the real estate post-petition? And the answer to that one is the real estate was acquired pre-petition, which is why the lender is saying, I have a lien in these accounts receivable. But the point is the sales contract arose post-petition, and that's the big divide on that particular case. That pre-petition, post-petition divide is really important. And then the next question that came in was that an unsecured lender who challenged the senior secured lender's security interest in the perfection. In that case that I was talking about, the real estate was actually unencumbered. Surprisingly, you know, how's it possible a borrower has unencumbered, you know, who messed up in the loan department, right? Why was that real estate not encumbered by our lien in the first place, right? Good question. We don't know. All we know is that property, in that particular case, it was unencumbered property. All right. We are about out of time, and I know we're not going to get through all of these quizzes. Let's do this last one because this gets into a basic situation. You have a lender who's an assignee of a note. The lender wants to foreclose on the property through judicial foreclosure. What do you have to do to show that you have standing to foreclose? And this case comes out of New York. And whoops, I got a little highlight there. Should have deleted that. You can see that there are a few requirements. The bank, the lender, had to show that prior to the filing of the lawsuit that it had possession of the note, that it was endorsed, and that the note was had an allonge that was firmly affixed. And that's a big deal because in this particular case, the note and the allonge were just two different pieces of paper, and the court says, hey, it's not firmly affixed. Raises the question, what does firmly affixed mean? Does it mean just getting the stapler, stapling it? My point here with this is that if you are taking in an assignment of documents and getting allonges, you want to make sure that you are getting them together so that it is clear that the note, the allonge, the documentation, the loan is coming to you as the lender, so that if you then in the future have to do a foreclosure, that you will be able to go ahead and do that. All right. We are really basically here at the end of the time. I guess, you know what, bonus section, right? We're going to run through these items really quick. The next two questions are actually really related. They deal with consignments. And the question is, when you get a consignor and a lender getting into a dispute over who has priority, what's the test? You'll see here in the answer that the test is whether the borrower or consignee is generally known by its creditors to be acting as a consignee for others. Well, who on earth is a consignee for others? Well, it's a pawn shop, all right? This case rises in a pawn shop type situation, okay? And that determines the answer. That's the test right there. So if you're dealing with consignments, this is the test in a nutshell that you need to be asking about whether we need to file a UCC1, or if my borrower is dealing with this, do they need to file a UCC1? I think it's always safer to just file it to be, better safe than sorry. And that goes to a key takeaway there at the bottom of the page, which is know thy borrower, right? A really important commandment in the terms of lending. Here's a related case. This comes out of Massachusetts. You have a borrower, a seller sells inventory, sells shoes to the borrower. They're held in inventory. The seller purports to hold title to the shoes until paid. There's no UCC filed. Lender doesn't know about this arrangement. The lender has a blanket perfected lien. Who has priority? You can probably guess it on this one. The lender wins this situation because, you know, you're a shoe sales place. You're not known to be selling stuff on consignment as a general matter. That's why the court here is ruling in favor here, because the borrower, as you can see here, the borrower's rights to sell the footwear products gave the borrower a right in the footwear, which allowed the lender to acquire an enforceable security agreement, right? So you get attachment, in other words. The key point of this is that, you know, courts typically don't pay much attention to title. Again, if you are selling, if you're representing somebody that's selling in this type of situation, they really need to protect themselves by making sure a UCC is put on file. Okay, so we are basically at the end of the hour, and it looks like I've covered all the questions. Hopefully this has been helpful for you. And if it hasn't, I apologize. My goal here, and again, I'm really sincere when I say this, is when I'm doing these in the upcoming webinars, my plan or goal is to genuinely try to raise these noteworthy cases, these things that are coming out that are kind of interesting, and then get the practical takeaways that you can apply or deal with, you know, just in your day-to-day work. So just a couple quick comments right here at the very end. If you're an attorney, again, my condolences, right? Not all attorneys are bad, right? It's, as we say, it's the other 98% that give the rest of us a bad name. But anyway, this has been approved for legal education hours. If you want to report your hours, there's the CEU icon at the bottom. There will be a certificate of attendance, including the course number, will be emailed to you tomorrow, along with the recording of the webcast for watching and viewing. Again, there are the handouts from the materials that you can have and look at those further. And the final point is, I'd really appreciate any feedback you can give. I want to genuinely make this more helpful and beneficial for folks like you in the future. So with that, I hope you have a good day. Enjoy the beautiful spring weather. And this concludes our webinar for today. Thank you.